close to a 20-year run now of ACS and the ACLU cooperating on this annual term and review program, and Mayer Brown being kind enough to host us. My name is Steve Sanders. I teach at at Indiana University Law School in Bloomington, but I was an associate here at this firm many years ago, and I'm privileged to come back and do this each year. Mark Kadish in the back, I was one of his pupils when I was a summer associate and a young litigator. He's a legend in the Chicago legal and pro bono and criminal law and litigation communities. Let me first of all again thank our sponsors, the Chicago Lawyer Chapter of the American Constitution Society, Peggy Lee, Megan Paulus, and their colleagues and team, the ACLU of Illinois, Kayla Flanagan, Emily Scott, and their colleagues and team, Tyler Moon, Joanna Horsnail, is she here, the managing partner of Mayer Brown's Chicago office? Let me acknowledge her for there she is, for being kind enough to welcome us here yet again. And the very nice lunch you're enjoying is courtesy of Mayer Brown. And so we really appreciate Mayer Brown's consistent support of this program. So, and thank you to Tyler Moon from the conference services staff. Again, Joanna Horsnail, the managing partner of the Chicago office, Mike Scodro, a partner here at Mayer Brown, who you'll hear from in a few minutes. And we have, in addition to a sold out in-person group here, we had something like 300 people registered to participate online. So this program gets a lot of reach. One of today's panelists, Aziz Huq, who you will hear from, in addition to being an incredibly prolific scholar, also writes regularly for The Atlantic and writes some very compelling commentary that you should be watching. And he recently wrote this. The three liberals on the Supreme Court agree on an overarching theme. They no longer see the court playing by the old game of constitutional law. Their dissents suggest anything but an assumption of business as usual. The three liberal justices are writing about a majority unbound by law and its tiresome technicalities, about a majority that is no longer doing law as that term director of law reviews. And so,
oh, no,
that's an error. That's on the website. Anyone who wants to publish should be talking to Steve about getting your article in print.
The school may have added that.
Okay.
Please just spell that really quick.
Okay, all right. But a law professor and longtime friend of this program from the University of Illinois, Chicago Law School. Mike Scodro, a partner in the Supreme Court and appellate litigation practice here at Mayer Brown. Carolyn Shapiro, who's professor of law and co-director of the Institute on the Supreme Court of the United States at Chicago-Kent College of Law. Kevin Fee, legal director of the ACLU of Illinois. Kevin is joining us, joining this panel for the first time this year, and is recently joined the ACLU of Illinois as legal director. So congratulations to him and welcome. And then Aziz Huq, the Frank and Bernice J. Greenberg Professor of Law at the University of Chicago Law School. So without further ado, we'll get started. Our format here is each of our five panelists will discuss two cases or two sort of major issues that the court dealt with this coming year. I've asked each of them to take no more than about 11 minutes altogether. Our aim is to finish with enough time to have some time for questions and answers from the audience. And we always wrap up, because we know you have other places to get. We will wrap up on time at 1:30. So again, thank you for being here. Thanks for being a part of this event. And Steve Schwinn, please get us started.
Thank you, Steve. Audio okay, everybody? Yeah, awesome. Thank you. Steve, thank you. It's a real treat and pleasure and honor to be here once again with everybody, with old friends on the panel and old friends in the audience. Thank you very much. Welcome to everybody online, and thank you again to Mayer Brown for sponsoring this wonderful opportunity and wonderful discussion. So I've been assigned a couple of cases that are going to depress you, and just to, I think I'm not going to give away anything.
They come every year expecting that by this point.
Yeah, I'm not going to give anything away by saying that I think it pretty much goes downhill from here on the panel. So buckle up and get ready. We are in for some rough times. The cases that I've been asked to talk about are Skrmetti and Mahmoud. These are two cases involving, on the one hand, LGBTQ rights, and on the other hand, religious rights. And the trend that we're seeing in these two cases is the court once again, and I say once again because we've seen this several times in recent terms, in recent decades, where the court is privileging religious freedom, religious exercise over LGBTQ rights, and minimizing LGBTQ rights substantially at the expense of religious rights, expanding religious rights. And what we've seen is on the court, what is this, in a 10-year plus trend now to expand religious rights, and in particular, expanding free exercise rights at the expense of the Establishment Clause. And what I fear with this one case we'll talk about today, Mahmoud, is that we are on the cusp of really empowering the free exercise clause in ways that we just haven't seen. I think a strand of free exercise jurisprudence seems to be going the way of the dinosaur, and I worry quite a bit about that. And I think in future terms, we're going to see more and more challenges to LGBTQ rights and expanding religious liberties. Let me tell you about these two cases. So the first one is Skrmetti. This deals with Tennessee's SB1, which famously is the ban on transition healthcare for transgender minors. And in particular, what the challengers were challenging here is hormone blockers and other drugs that would be used for transition therapy for transgender minors, and just banning it, saying you can't do that. Parents and minors and healthcare providers brought a challenge. They argued that it violated the Equal Protection Clause. And what they argued was that this discriminated based on sex, looking to the Bostock case that you might remember from a couple of terms ago, and it discriminated based on transgender status. Now, I want to pause here just for a second and remind you of some things that we learned in law school. So we know that sex discrimination under the Equal Protection Clause gets heightened review. We know that it gets intermediate scrutiny under the Equal Protection Clause. But we don't know what discrimination by transgender status gets under the Equal Protection Clause. That's a question the court has not yet answered. And this case potentially teed it up. What standard should the court use to assess discriminatory efforts on the part of a state that discriminate against individuals based on their transgender status? And so the case went to the Supreme Court, and the court rejected the claim entirely. What the court said is this is neither sex-based discrimination nor transgender-based discrimination. Instead, what the healthcare law does is discriminate by age, right? Remember, it applies to minors, and the health services that are allowable to that population, the transgender health services for transgender youth. And so what the court said is, because this discriminates on age and health services that are available to this population, we're just going to go ahead and apply the lowest level of scrutiny, rational basis review, and under rational basis review, the law easily pass. The court looked to the legislature's interest in the youth's health currently and in the future. They pointed to what they called a scientific dispute, a deep scientific dispute about the state of transgender health services and transitional services, and said, look, we're going to defer to the legislature on this, and we're going to leave it to the people to decide a question like this. That was the upshot. Now, along the way, the court sort of resurrected a case that many of us every year when we teach this kind of thought and hoped that it went away, a case called Geduldig versus Aiello. You may remember this from law school, where the Supreme Court kind of amazingly said that discrimination on the basis of pregnancy is not sex-based discrimination. Now, if you don't remember Geduldig, or if that idea is new to you, I'll give you a second to let that sink in, because it's a very strange idea. What the court said was, classifications based on pregnancy divide the world into two classes. On the one hand, there's the class of pregnant people. And the court acknowledged in Geduldig, all pregnant people are female, okay? The problem was the other class of non-pregnant people, the court said, includes both pregnant people and non-pregnant people. And for that reason, a classification based on pregnancy doesn't discriminate by sex. Well, you can see how that might apply to this case, right? And what the court said was, this classification doesn't classify by sex or transgender status because the classification divides the world into two, just like a pregnancy classification. Individuals who are transgender and seeking medication to transition. And what the court said is, we'll acknowledge that that class is transgender youth, transgender individuals. But the other class in the case, the other classification under the statute, under the Tennessee law, was a classification of individuals who were using drugs and hormone therapy for other purposes, which the law allowed. And what the court said, I thought was kind of interesting. The court said that classification, individuals who are using hormone therapy for other purposes, includes, sure, it includes some transgender individuals. It also includes non-transgender individuals, just like non-pregnant people include both males and females. And the court said applying Geduldig to this case, therefore, means that there's no discrimination based on sex or transgender status. And so again, we apply rational basis review and it easily passes. We saw a couple of interesting concurrences in the case. Thomas concurred, which may be not so interesting. Justice Thomas, you can almost kind of imagine him donning his medical robe and gear and giving his professional medical opinion at length in this case, saying exactly why the Tennessee legislature was right to ban transitional care for transgender youth, because this is just such an unsettled science. And of course, Justice Thomas would know that. So he tells us at length exactly how he does that. The more interesting concurrence came from Justice Amy Coney Barrett, joined by Thomas. Now, this was a concurrence that was utterly unnecessary. And for those of us that have been thinking, you know, maybe Amy Coney Barrett, maybe she's a kind of interesting justice, somebody to keep an eye on. Maybe she's not always going to side with the conservative majority in these cases. Well, let me tell you otherwise. And then I think Aziz is going to tell you otherwise in a different way later in our presentation. She wrote a concurrence that said, look, even if this does discriminate by transgender status shouldn't get heightened review. And she applied the traditional factors that the court uses to determine whether a classification ought to get heightened review. And she said, it just doesn't add up for individuals of transgender status. Now, remember, the court didn't rule on this. The court left the question open. So this opinion was entirely gratuitous. There was no purpose to it that I can tell, other than to signal her willingness to say that transgender status does not get heightened review. So we now have Justice Amy Coney Barrett, Thomas, and Alito, because Alito concurred in the case as well for similar reasons, saying that transgender status does not get heightened review. 3 full justices on the record saying that, with a couple of cases coming down the pike next term that are going to test that principle. We saw a fiery dissent by Justice Sotomayor, and you got to read this. You got to read her other dissent that we'll talk about. And of course, Carolyn's going to talk about the shadow docket cases. If you haven't read Justice Jackson, wow, you got to read these dissents. They're fabulous. They're fantastic. What she called out was all the obvious problems with the court's analysis. And she said, this is indeed sex-based discrimination by the same sort of reasoning that the court applied in the Bostock case. And it is discrimination based on transgender status. And indeed, transgender individuals ought to get heightened review. Kind of an easy case to make, it seems to me, but she made it plain and she made it powerfully. I really recommend that opinion to you. The second case I want to talk about is Mahmoud, and I'm keeping my eye on the clock. We'll talk about this very quickly. This was the Montgomery County, Maryland school system that introduced a curriculum that had 5 LGBTQ inclusive books as part of it. that they used in the classroom. Now, for a period of time, the school system said, we're going to allow parents to opt out of this curriculum if they want to, but that proved, surprise, that proved unworkable for the school system. And so the school system then went back and said, no more opt-outs. We're just going to go ahead and do this with these 5 books. So parents complained and they raised their religious freedom. They said, we have a fundamental right to raise our kids the way we want to, according to our religious faith. And they pointed to some prior Supreme Court precedent that didn't quite say exactly that, but came close enough to kind of squinted, they could kind of make their case. And so they made the argument and they persuaded that same 6-justice majority that they were right. They deserve an opt-out opportunity. They have a fundamental right to opt their children out of this LGBTQ inclusive curriculum, the books that the school are using. The linchpin here for the majority was that these books, they were what the court called normative. And what the court meant by that is that the school district was pushing a particular belief on parents who didn't want that belief to be shared with their children. Now, the prior Supreme Court cases didn't go quite that far. In fact, they didn't go near that far. They said something entirely different, but that's okay for the court. It stretched those cases to this new principle that will likely have dramatic consequences. Children in my neighborhood are already organizing a religious faith that objects to mathematics. And so I think that's going to be the next challenge coming down the pike. But in all seriousness, I mean, you can imagine all kinds of challenges. It wasn't that long ago. And indeed, there are still some sects today that have religious objections to, for example, marriages of people of different races, right? And so how far this principle is going to go and the kinds of challenges that it will invite, I think remain to be seen. But we're going to see a number of challenges soon. Again, a very fiery Sotomayor dissent. I commend it to you. Between the 2 cases, again, I think what we're seeing is the court stripping LGBTQ rights and dramatically expanding religious liberties, allowing, inviting, even requiring religion to play more and more a part of our public life. And I think that's what we're in for at least until we see some changes on the court.
Next up, Mike Scodro, who actually has a couple of cases that demonstrate that not everything on the Supreme Court is 6-3.
Exactly. I have 2 cases that have 3 commonalities. One is that they, maybe more, but one is that they are both unanimous decisions. Another is that they both involve instances where courts made the effort to add an element to an anti-discrimination case. And both involve instances where the respondents, once they got in front of the court, probably seeing the writing on the wall, tried desperately to distance themselves from the opinion below, even though they had prevailed in the opinion below. So that's the commonality. And with that, I'll start with Ames versus Ohio Department of Youth Services. The factual situation here is pretty straightforward. In 2004, the plaintiff petitioner, Marlene Ames, took an executive secretary position with an Ohio Department of Youth Services. And she was in that position for 15 years, then promoted to something called a program administrator in 2019, and then more recently applied for a new position in a new office called the Office of Quality and Improvement. She interviewed for that position. She was denied that position. And not only was she denied that position, they then informed her that she was being demoted from her position as program administrator and was now back down to where she had been when she started as an executive secretary with a significant decrease in salary. Petitioner plaintiff Ames is a straight woman. The agency hired a lesbian woman for the Office of Quality Improvement position for which she had applied, and a gay man for the program administration job from which she was demoted. In response, she sued under Title VII, claiming discrimination on the basis of sexual orientation. Now, among other things, Title VII bars disparate treatment by employees on the basis of a number of categories, which I'm sure are familiar to folks in the room: race, color, religion, sex, including sexual orientation, national origin. In 1973, the U.S. Supreme Court had decided a case called McDonnell Douglas, probably familiar to many, many in the room. It established a 3-step sort of burden shifting process between the employer and the employee to work out cases in which disparate treatment was being claimed based on circumstantial evidence, which is a case like this. Well, this case is all about the first of the three McDonnell-Douglas factors, the so-called prima facie case, which requires the plaintiff in the first instance to establish or produce evidence to show discriminatory motive. Generally, this is not a terribly high burden. The court recognizes this. Usually the employee has to show that they applied for the position. That box was checked here, that they were qualified. That box, I guess, was checked here. I don't know the details of her qualifications, but there was no dispute at this point. That box was checked. And that she was rejected from her position under circumstances giving rise to an inference of unlawful discrimination. Those boxes, Ames claimed, had all been well checked by her claim in this case. But in some circuits, including the Sixth, where Ohio lies, if the employee is a member of, or deemed to be a member of, a majority group, they must also establish an additional element, namely some background circumstances that support the suspicion that the defendant is, and I'm using the court's words, the defendant is that unusual employer who discriminates against the majority. She failed to make that additional showing here, and therefore her claim failed in the district and appellate court. The question before the Supreme Court is whether Title VII actually includes this extra requirement for plaintiffs who are deemed to be in the majority. Here, she was a straight person bringing the claim. Justice Jackson, writing for a unanimous court, in a rather short opinion, says no. Now, the points were very straightforward. The analysis is straightforward and will be very familiar to you. It's the way that we typically write briefs. She said, first, the text is absolutely at odds with that idea. The statutory text in Title VII bars discrimination against, quote unquote, any individual, and that without differentiating between whether that individual is in a majority or the minority. And then she cites, and again, very sort of quick fashion, a number of past decisions by the court where the court had refused to apply different legal standards, in fact, had spoken in terms of applying the same legal standards under Title VII to plaintiffs, regardless of whether they were in the majority or minority, members of majority or minority groups. Now, Ohio, perhaps seeing the writing on the wall when the case was granted, basically did not, in fact, defend using two different tests. Instead, what they said was, well, look, what the Sixth Circuit was really doing was just in talking about these background circumstances supporting this inference, what the Sixth Circuit was really doing was just sort of fleshing out or providing a new way of articulating, of phrasing the long-standing first step of the McDonnell-Douglas test. It was just a different way of putting it. Justice Jackson gives that the back of the hand, almost comedically in her phrasing at that point, and says that is absolutely not what happened. The Sixth Circuit decision talks about adding a factor, not about rephrasing what is the first factor. And so the court made short work of Ohio's sort of argument that there's nothing to see here. This was a mere kind of rearticulation of existing law. It's interesting in this case, and perhaps one of the more interesting elements, frankly, going forward is, again, a concurrence by Justice Thomas, and this one joined by Justice Gorsuch. The concurrence makes the point that the two concurs would actually be willing, not only, they think the court got this exactly right, they join the Justice Jackson opinion in full, but they would go further. They understand this isn't the case to do it, but they welcome all comers to give them an opportunity to do it. And what is that? They want to abandon McDonnell-Douglas outright. They say, look, this case shows all of the perniciousness that comes with a judge-made gloss on statutory text. That was true of this additional element the Sixth Circuit and a few others had added. It's equally true, he writes, Justice Thomas writes, it's equally true of McDonnell-Douglas. It appears the three steps of that test appear nowhere in Title VII, and therefore should not be the law. And it's sort of inviting. We'll see what happens. We can all, I think, imagine and expect there will be cert petitions raising precisely that argument. And that'll be interesting, as we were discussing earlier. It's not necessarily, McDonnell-Douglas isn't necessarily an ideologically aligned One could imagine attacks on it from both right and left. We'll see what happens when those petitions start to roll into the court. The second case that I was asked to speak about, also unanimous, this time an opinion by the Chief Justice, ALT versus ACLU area schools. This is a case really about three anti-discrimination laws and how they work together. The most specific of the laws at issue is the Individuals with Disabilities Act, the IDEA. Many are probably familiar with this statute. Provides federal funds for states, and in exchange for those federal funds, the states have to ensure special education and related services, including instruction tailored, and I'm reading from the statute, to meet a child's unique needs and sufficient support services to permit the child to benefit from that instruction. Now, chiefly, those aims are achieved through IEPs, individualized education programs. Those are designed ideally cooperatively between the student's parents, and the school, but the law recognizes that those folks may not always agree on an IEP, and therefore there is a right to administrative review before an administrative law judge, and from there into state or federal court. Well, this case involves petitioner AJI, who used that IDEA process with extreme success. She suffers from a very serious case of, she has a very severe epilepsy. She has seizures that are debilitating for the first part of every day until about noon. And she's able to study, to be part of a class from noon until about 6, sort of her window that her epilepsy allows her to focus on her schoolwork. Her parents requested an IEP that would allow her to receive schooling that started at noon and then went later in the day. The school refused to provide instruction after the end of the normal school day, and the parents proceeded before the administrative law judge and ultimately to a federal district court and a federal appellate court. All of them agreed with the parents and with the student, AJT, and so she received her IEP. At that point, the parents filed a new federal lawsuit under the other two statutes at issue here. One is Title II of the ADA, which prohibits disability discrimination in a broad range of topics. And the other is Section 504 of the Rehabilitation Act, which also provides broad prohibitions on disability-related discrimination. They sued under both, and they sought a permanent injunction and damages under those statutes. The district court agreed that AJT had made out the basic elements of discrimination required to satisfy those claims, both of those statutory claims. But the Eighth Circuit had a rule, and some other circuits did as well. And again, this is just like the last one, an extra element. In this case, when the discrimination occurred in the education context as opposed to other contexts, there had to be an additional showing of bad faith or gross misjudgment on the part of the school district. Now, why did this come about, this sort of extra requirement, this extra burden on plaintiffs in the school context? It's because of the IDEA. The Chief Justice traces back the beginnings of this additional element and finds that what courts had been trying to do is reconcile the IDEA, which provides these very specific tools to remedy discrimination against disabled students in the education context, with these broader prohibitions in the Rehabilitation Act and Title II that apply across the board to disability discrimination. How can we have both? Don't the latter just make the former essentially unimportant? And the court, in fact, the U.S. Supreme Court in a case called Smith back in '84 had gone so far as to say that, yeah, we really can't reconcile these. So the IDEA is the only remedy for disabled students seeking relief on the basis of discrimination in schools. Congress very rapidly overrode that and said, no, you have the right to all three. You just have to exercise your IDEA rights first and exhaust that process, which she did here. So the court here makes short work of this and says, basically, there's no way to reconcile Congress's overruling of our decision in Smith with the idea that there's an extra burden, an extra hurdle that plaintiffs have to overcome when they're claiming that their disability discrimination occurs in the context of primary or secondary education. Ultimately, the district like the state of Ohio in the last case, declines to defend this distinction and instead claims, well, it should be bad faith and gross mismanagement. That should be the standard that applies across the board under all three statutes. And so, or at least under the two, Rehabilitation Act and Title II. And so it really doesn't matter that there was a distinction here. What matters is that everyone should be subject in all contexts, education and beyond, to this higher standard. The court said that is not the question before us, and we're not answering that. And then you have two sets of concurrences, Justice Thomas and Justice Sotomayor, taking opposite positions on that question. Thomas saying it should require a showing of animus in all cases under Rehabilitation Act and Title II. Justice Sotomayor saying there should be no requirement of a showing of animus under either. So that too will have to be reconciled going forward.
We don't, constitutional law and administrative law are typically two different subjects in law school, but in recent years, the Supreme Court seems to be blending those, and the sort of hostility toward administrative agencies takes on a separation of powers dimension. So Carolyn Shapiro has an interesting kind of case along those themes.
Thank you, Steve, and thank you to the ACLU and ACS for sponsoring this. It's a pleasure to be here, even if a little depressing. Although the case I'm going to talk about two things. First, I'm going to talk about a case that is not so depressing, and then I'm going to talk about the shadow docket. And they are pretty unrelated. So just bear with me. I have 11 minutes. So this is going to be a little bit of a speed test here. The case I'm going to talk about is Federal Communications Commission versus Consumer Research. And this is a case involving an attempt to revive and, in my view, really expand the non-delegation doctrine. Now, you might remember learning about the non-delegation doctrine in law school. The non-delegation doctrine is the principle that Congress can't delegate too much of its legislative authority to administrative agencies. So it can give administrative agencies discretion, it can set policy, that allows those administrative agencies in the executive branch to make a variety of different policy decisions, sub-policy decisions, but it can't say, do good stuff, now we're done, right? It has to provide what the courts have called an intelligible principle. And that intelligible principle has actually been interpreted pretty broadly to give Congress quite a bit of wiggle room in what it delegates to agencies. And as you may recall from law school, that there has not been a law that's been struck down under the non-delegation doctrine since the 1930s. So people have generally thought of the non-delegation doctrine as being pretty moribund, but there's been an attempt in the conservative legal movement to revive it. And in 2019, in a case called Gundy versus United States, the court seemed to come pretty close to doing that. In Gundy, there was a non-delegation doctrine challenge to a case involving sexual offender registration requirements and delegation to the Attorney General to figure out how to apply those registration requirements to individuals who were convicted of sex offenses but had been released from prison before the law went into effect, because the primary requirements was registration by these sex offenders before they leave prison. That was decided on a 4-1-3 basis. Justice Kavanaugh did not participate in that opinion. The then four liberals, Breyer, Kagan, Sotomayor, and Ginsburg, said this is a perfectly ordinary case of intelligible principle. Gorsuch, Thomas, and Alito said, we think it's time to revisit that, and we think this case is a violation of the non-delegation doctrine. And Justice Alito said, well, I'm not prepared to do that in a case where we only have 8 members of the court. I think the majority is, or the plurality is applying our precedent, and so I'm going to join to concur in the judgment. So so people thought, oh, well, it's not going to take very long. So for us to see the end of the non-delegation doctrine permanently, that doesn't seem to have happened in this case. In this case, the issue has to do with this provision of the Communications Act that requires the FCC to attempt to provide universal service by doing a couple of different things. One is to identify what types of telecommunications service should be provided universally. Right now, for example, broadband access is one of those things. Obviously, that has not always been true because we haven't always had that. But there are some criteria in the law for how to figure out what those types of services should be, and then to levy a contribution rate to telecommunications providers to subsidize the provision of that service in places that otherwise wouldn't be able to get it at, because it's otherwise too expensive to provide, like in very rural areas, for example, especially rural hospitals, to libraries. There's a handful of other beneficiaries of this. In this case, the court said that in a 6-3 decision, the court said there's no non-delegation problem here. Yes, the FCC has discretion to figure out what types of services it's going to say have to be subsidized. And yes, it has discretion to set the rate at which those contributions are going to be made by the telecommunications companies. And yes, there's an additional piece that there's a private entity that advises the FCC. But nonetheless, the court said there's an intelligible principle. Actually, there are several intelligible principles. There's a lot of guidance in the statute. And we think this is basically a pretty ordinary case of appropriate delegation. Justice Gorsuch, as he did in the Gundy case, wrote the dissent, joined by Justices, again, Alito and Thomas. And I would say the thing that's most interesting to me that is parallel in these two cases, Gundy and FCC, is that the real disagreement, more so in Gundy, but also in this case, but the big disagreement is about statutory interpretation. The majority and the plurality in Gundy say, well, look, this is what we think the statute says and does. And Justice Gorsuch reads the statute to provide extraordinary amounts of discretion, way more discretion than the majority/plurality reads the statute. And so I think one thing that suggests to me is that the non-delegation doctrine, were it to be revived, would actually be extremely malleable, because it would be possible to read different statutes to provide more or less discretion depending on how much you like those statutes. And that reminds me of another reason why perhaps we didn't see the demise of the non-delegation doctrine, which is the rise of the major questions doctrine, which is a statutory interpretation doctrine that says, well, if an enormous amount of decision relating to some kind of really big political or economic area appears to have been delegated to an agency, but not expressly, we're going to decide that that's not actually what the statute means. Hello, textualism. And we'll say that the agency doesn't have this authority that it's claiming. It's also very malleable, but it does seem to be a version of non-delegation light. And it seems to be functioning in that way. And it's not a constitutional doctrine, so it has that going for it. Okay, now the shadow docket. You've all, I'm sure, been reading about the shadow docket and all of the decisions that the Supreme Court is issuing, staying either all or some parts of lower court preliminary injunctions against the Trump administration. There are, by my count, 16 times that the Trump administration has gone to the Supreme Court to ask for that kind of relief. And although it hasn't received complete relief in every one of those instances, it has received some relief in every one of those instances. I could say a lot about the specific cases, but I have 3 minutes and 15 seconds left. So I'll just say a little bit about what I see as really problematic. And I am actually recently started writing a recurring column for SCOTUS blog, so you can read more about what I think there. The court, first of all, in many of these cases, is intervening at a point when it really would not intervene in an ordinary case. It is coming in at a very preliminary stage, and it's not allowing the litigation to develop the way it ordinarily would in most forms of litigation. Now, there are times, I think, where it's actually appropriate for the court to do that. I don't think it's never appropriate for the court to do that, but I think the onus should be on the court to explain why this is one of those times and why it's acting, and it really hasn't done that at all. In Trump versus Casa, which Aziz is going to talk about, I think there's some hints about why. I think that there are members of the court who appear to believe that restricting the executive branch is by definition some kind of overwhelming irreparable harm. So that's one thing. And what that also does is it turns the court from what it has always proclaimed it is into a court of error correction. So we said we're not a court of error correction, right? Where we make big decisions, we decide important cases, we address we ensure uniformity of the law, but we're not a court of error correction. Well, they're acting like a court of error correction in these cases. And they, at the same time, are not providing any, in many of them, providing no reasoning whatsoever, like zero. And in some, in about half of them, they provide no reasoning whatsoever. And in a little more than half, they provide some amount of reasoning. That's a very generous, right? When I say some amount, that's a pretty generous description. In some cases, it's some reasoning. In some cases, it's like a gesture at some reasoning. But that's only in about slightly more than half of the cases. So the lower courts, of course, including in the very cases that they are issuing these stays in, don't know what the court thinks, may not know what the court thinks they did wrong. And there are lots of other cases that obviously are in the pipeline or that are being actively litigated that to which these decisions, unreasoned decisions, might be relevant. The third thing that they're doing is, I think, changing the law in some areas without saying so. That is one of the areas of dispute between the majority and the dissent. The dissenters, the three liberals, have not dissented in every one of these cases. Actually, Justice Jackson has dissented in every one of these cases. Justice Sotomayor has dissented, I think, in all but one. There's an asterisk. There's one case that's a little different because the government didn't get its full relief, so it's harder to count. And then Justice Kagan, I think, has joined the majority in two. Actually, I think she and Sotomayor have joined the majority in two. And they have not always explained themselves either when they've done that, which I think is a mistake on their part. The final thing that I'll say about what this practice is doing is I think it's actually having a pretty significant negative effect on the overall legitimacy of the judicial branch that the court may or may not be intending. But the government is now filing applications with the Supreme Court in which they say a version of, there's an epidemic of overreach in the district courts. There are all these preliminary injunctions that are being issued against us, and then they have a footnote with a bazillion cases because as you undoubtedly know, there's some different counts, 160 or more cases that have been filed. Many of those cases have resulted in preliminary injunctions. So what the government is saying is the lower courts are out of control, and Supreme Court, you need to set them right. But they're not actually bothering to appeal all of these cases or to file emergency applications in all of these cases. Instead, they're trying to paint with this really broad brush and say there's this epidemic of overreach in the lower courts. And I think that I don't know that they have registered that that's one of the effects of what they're doing. But I can talk about the shadow docket forever. But I am now at time. And so we can talk about it in the Q&A if there's time and interest.
This is Kevin's first year with us, and I think this might be one of his cases, might be the first case where there's a parental warning possibly necessary before you talk about it. I don't know, that'll become clear in a minute.
I will try to keep it clean, as I always typically do. So they say the path from the ridiculous to the sublime is but one step. I truly get to travel the full path from ridiculous to sublime today because I get the porn case and the religious charities case, and both involving the First Amendment, both boiling down to when and whether strict scrutiny applies. So first, the porn case, naturally, Free Speech Coalition v. Paxton. And, the fact that that's sort of a laugh line, I think, isn't actually an important part of the story here because, on its face, this is a case that involves pornography, which is something that most folks would prefer not to talk about, much less, appear to defend. And specifically, it has to do with minors' access to pornography online. And, I think it's fair to say this is something that's broadly concerning to people of lots of ages and political stripes. And, the fact that youth have one-click access to essentially all the pornography in the world now is something that a lot of us are still grappling with. And so the headline that I think a lot of folks took away from this case was, Supreme Court makes it harder for kids to access porn online. And a lot of people probably thought, phew, one less thing to worry about, right? But all of this is what kind of makes this the perfect case for the court to smuggle in some truly, doctrine obliterating concepts that could upend the way that First Amendment jurisprudence is done, for years to come, which in my opinion is exactly what happened here. So to dig in a little bit, this case involves a statute, a Texas statute, HB 1181. It requires commercial websites that publish explicit material to verify the age of their users. So which websites? This is websites that offer at least 30% of their content as sexually explicit material. So by definition, sweeps in lots of non-sexual content. Also, sexual content in and of itself is fully protected by the First Amendment, at least as to adults. And what does age verification mean? Well, it means some commercially available age verification software using either a government issued ID or some other transactional information. It basically means a user has to input their personal information to a porn website or a third party that porn website chooses and have that entity keep its personal information saying, I want to look at porn for the rest of time. So, in the time when we have, media mergers and subpoenas for online information, not an insubstantial privacy burden and privacy concern. So the plaintiff was an industry group that sought to enjoin this law. It won in the district court. They applied strict scrutiny because it was, in their view, a content-based restriction. Fifth Circuit reversed, holding that no, in fact, this only applies to obscene material for minors. Therefore, First Amendment doesn't even apply. Rational basis. And then the Supreme Court says, no, you're both wrong. Reverses the Fifth Circuit and continuing the Fifth Circuit's losing streak this term. Says you're both wrong. It's actually intermediate scrutiny. Usual 6-3 split, conservatives versus liberals, Thomas for the majority and Kagan in dissent. So, it's worth spending some time, I think, on just bedrock First Amendment principles here, because this case really just comes down to the mechanics of the way that First Amendment challenges typically play out before federal courts. So the lodestar of First Amendment, free speech jurisprudence is that the government has no power to restrict expression because of its message, its ideas, its subject matter, or its content, right? So because of that, if laws that target speech based on their content are subject to strict scrutiny review and all of its, concomitant requirements, a searching review, a difficult standard to overcome. So a step below that in speech cases is intermediate scrutiny, which is typically reserved for content neutral laws that only incidentally burden speech. So think, a rule that prohibits people from walking on an expressway is, designed to keep you from getting squashed by cars. It's not, aimed at your speech. Now, if you want to have a protest on the expressway, suddenly that law now implicates First Amendment concerns, but it gets that lesser level of scrutiny because it's only incidentally burdening speech. And then you've got the lowest level of review, rational basis, which in speech cases is reserved to those relatively narrow categories of speech that get no First Amendment protection at all. Think, defamation, fraud, and important to this case, obscenity. So just pause for a second there. Obscenity, that famously undefinable concept, right? That one Supreme Court justice said, I know it when I see it, right? Is something that typically doesn't come up in cases involving adult access to sexually explicit speech, at least so far, knocking on wood here, but it is relevant in cases involving minors because there is a lower obscenity standard for minors. That's what allows states to regulate minors' ability to access sexual content as long as it doesn't unduly burden adults' ability to access the same content, right? So those are the three levels, right? And the question of minors' access to adult content on the internet is not new, as the opinions in this case make very clear. There have been multiple attempts to restrict minor access to pornographic content online. In every one of those cases, the court has applied strict scrutiny. So what happened here? Why didn't the court apply strict scrutiny for the first time ever in this context? Is it because they said it was just about obscenity? No, they don't do that. That's what the Fifth Circuit did. But the majority does concede that this statute burdens adult protected speech rights. And so as it must, because obviously these websites that are regulated by this statute are accessed by both adults and potentially minors. So what happened here was far stranger. And I think it's worth spending a little bit of time reading from the opinion authored by Justice Thomas. So this is from page 18. So first, Thomas concedes that, quote, adults have the right to access speech that is obscene only to minors. Okay. Second, submitting to age verification is a burden on the exercise of that right. So timeout. That's usually where the inquiry ends. It's strict scrutiny all the way. You've got a clearly content-based law. Adults have the right to access this material, and there's a burden on it. So strict scrutiny, right? Well, here's the twist. So Justice Thomas goes on to say, quote, but adults have no First Amendment right to avoid age verification, and the statute can readily be understood as an effort to restrict minors' access. So any burden experienced by adults is therefore only incidental to the statute's regulation of activity not protected by the First Amendment. So, look what he did there. He did a couple of interesting things. First, he took the right of adults to access this protected material, and the burden that the court's supposed to be evaluating on that right, that is the age verification system, and he just sort of smushed them together, right? He made, but the problem is that it's not the right to avoid the burden. The right is the free speech rights, right? If you can do this trick in any free speech case, you can just say, so your law burdens free speech, but you don't have the right to avoid that burden. So no burden to worry about, right? It's like magic. Poof, the burden disappears. So that's step one. Then step two is, in addition to defining away the right in a way that sort of makes it hopelessly conflated with the burden, he redefined what an incidental burden means, which is the linchpin of intermediate scrutiny and when it applies. So Justice Thomas goes on to discuss the incidental burden on speech that's supposedly attached to this regulation in this sort of squishy way, as if incidental just kind of means a burden that's no big deal, but incidental burden doesn't mean, a more chill, casual sort of burden. Like it doesn't mean, a burden that we care less about. It means an indirect burden on speech, as distinguished from a direct burden on speech. Think about the walking on the highway example. It doesn't directly burden speech. It just incidentally burdens speech in some instances. But here, there's no question the age verification burden is directly aimed at sexual content because it's sexual content. There's nothing indirect about it. It very directly burdens speech. So this whole concept is a brand new invention. So Justice Kagan's dissent does a really good job of going through all this, and I urge you to read it. It really takes Justice Thomas to task. And, the thrust of her argument is nobody is saying that there's no harm here. Nobody's saying necessarily that the state doesn't have a strong interest, or even that this law wouldn't survive strict scrutiny. But let's just apply strict scrutiny like we always have in the past. Put this law to the test. Decide if it is indeed the least restrictive means of advancing the state interest. But of course, that does not happen here. There's really no consideration of the privacy burden at all, or of the overbreadth of the category of speech that's covered. It all just gets sort of swept away in this sort of redefining of terms. So, what are we left with? I mean, at least when it comes to minor access to material that the state deems to be sexual in nature, the court's just going to read the scrutiny part of the analysis, apparently, right out of the equation. And it's not hard to see how this could have broad implications, especially in this moment when there is a political movement afoot to dramatically expand the scope of what is considered inappropriate sexual material, including, to include things that just talk about the existence of LGBTQ people or trans people. I mean, the Project 2025 defines pornography as including so-called transgender ideology and seeks to jail the purveyors of that pornography. So it's not hard to see how this seemingly sort of common sensey sounding opinion on its face could be expanded in really pernicious ways. So we have a pretty substantial weakening of the protection of speech as long as the state can plausibly claim an aim to protect the children. So I'm sorry, I cheated. I spent too much time on the foreign case, but I hope you'll forgive me because the next case, Catholic Charities Bureau, is a unanimous 9-0 decision. It lacks a little bit of the narrative punch of the foreign case, but it's nonetheless quite important. So this case involved a Wisconsin law that exempts religious nonprofits from paying unemployment compensation taxes. The Wisconsin Supreme Court denied the exemption to the petitioners who were charities that were organized under the Archdiocese of Superior, Wisconsin. It denied it because it found that the charities weren't sufficiently religious to qualify for the exemption. And that's because the charities didn't engage in proselytization or limit their charitable services to Catholics. Now, in a unanimous decision authored by Justice Sotomayor, the court held that denying the exemption, as the Wisconsin Supreme Court did, was religious discrimination and therefore subject to the strict scrutiny that we just discussed, which it didn't pass. So the real error in the Wisconsin court's analysis, according to Justice Sotomayor, is that they ignored that Catholic Charities Bureau's decision not to proselytize was itself rooted in Catholic doctrine, which counsels against conflating, charity with proselytization. So all in all, this was a fairly narrow opinion that really turned on sort of this very specific Catholic theological doctrine. It did not go as far as the petitioners or some of the amici had hoped, but it's still, I think, reasonably likely to be applied broadly and without that sort of nuance by those who would seek broader and broader exemptions from state burdens for religious organizations. But in all, it did uphold, kind of broad separation of church and state principles pretty well.
Kevin, thank you. Carolyn's presentation suggested the role that the critical role that district courts and district judges play in the rule of law. And one of the cases that Aziz is going to talk about really has that issue at its heart.
Thanks, Steve, and thank you to ACS, the ACLU, and especially Mayer Brown for their generous hospitality today. It's very much appreciated. The two cases I have to speak about are Trump versus CASA and Trump versus JGG. And rather than doing each case in turn, what I want to do is to offer a series of 4 parallels between the two cases that I hope draw attention to some systemic features of the Roberts Court today, maybe our particular moment today too. So these are cases that have 4 kinds of parallels. First, they emerge from the same ideological matrix. Second, they arise against the same pattern of executive branch non-compliance, either with clearly established law or with court orders. Occasionally, this is covered by what my casebook co-author Leah Littman calls legalistic non-compliance, but it is non-compliance nonetheless. Third, in both cases, the Supreme Court finds for the government on the ground that the constitutional right holder employed the wrong procedural vehicle. And finally, the effect of that procedural ruling in both cases is to undermine the credibility and legitimacy of lower courts, picking up on something Steve said, in ways that are likely to increase the rate of executive branch non-compliance with the Constitution and statutes, and even in the absence of non-compliance, will expand the number of people who lose statutory or constitutional rights without a plausible pathway to a constitutional remedy. Those are the four commonalities. Let me go through them in turn. First, both of these cases emerge from executive orders that advance a nativist and racially exclusive vision of membership in the US polity. What's at stake in both of these cases is what the philosopher and one-time Chicago academic Hannah Arendt called the right to have rights. These are cases about who is in and who is out of the legal community. Both cases emerge out of executive orders. So on January the 20th, the president issued an executive order that purported to limit the availability of birthright citizenship, which is otherwise guaranteed by the 14th Amendment's first clause, reversing Dred Scott, purporting to limit birthright citizenship eligibility to certain people based upon the immigration status of their parents. And there are details that I won't go into. It's worth flagging here that in 1898, in a case called One King Ark, the Supreme Court affirmed the ancient and fundamental rule of citizenship by birth within the territory and the allegiance and under the protection of the country includes all children here born of resident aliens. That's one case, the birthright citizenship case. Second, in 1798, Congress passed a statute called the Enemy Aliens Act that allows for the detention and expulsion of enemy aliens. It's only been invoked until this year 3 times in American history. All of those times were in wartime. On March the 15th, the president designated a Venezuelan criminal gang called Tren de Aragua as a group covered by the AEA. The timing of the order is notable. Earlier in that day, a group of Venezuelan nationals represented by the ACLU who believed that they were about to be designated filed a lawsuit under the APA, the Administrative Procedures Act, challenging anticipatorily that designation. The designation comes down later that same day. By that evening, the people who challenged the order are on planes heading for El Salvador. These planes leave American soil at 5:26 and 5:44. A district court judge, James Boasberg, in DC, grants a temporary restraining order and verbally and then in writing orders the United States to turn the planes around at 6:58. That's the posture of the case. Second commonality. Both of these cases demonstrate the ways in which the executive branch, either in word or deed today, does not comply with clearly established law or with court orders. Let me flip the order around and start with the AEA case now. At the time of Boasberg's orders, the planes were over the Gulf of Mexico. It is still called the Gulf of Mexico. Neither plane, you're taking away my 11 minutes. Neither plane was turned around. When the planes landed in El Salvador, El Salvadorian President Nayib Bukele posted on X, and I quote, "Oopsie, too late," which was retweeted by Mario Rubio. The government offered a number of arguments for why the court failed to comply. The arguments are best described as specious. In the birthright citizenship case, Ronald Reagan appointee, District Court Judge John Kuenar, described the executive order as blatantly unconstitutional. He and 2 other judges in Maryland and in Massachusetts issued orders barring the Trump administration from enforcing the birthright citizenship order, in part because of its effect upon states, which were plaintiffs in the case, and which would be subject to unexpected fiscal burdens if certain people were removed from the category of birthright citizenship. Notably, in the Supreme Court, in the birthright citizenship case, the Solicitor General said, in effect, we promise you, the justices, that we will comply with orders from the Supreme Court. We will make no such promise with respect to district courts and with respect to the courts of appeals, which puts the shadow docket question in a different light, right? So non-compliance. Third, in both cases, the Supreme Court found in favor of the government on the ground that the litigant, the private litigant, had used the wrong procedural vehicle. In the birthright citizenship case, the court ruled as a statutory matter, interpreting the 1789 Judiciary Act, that federal courts exercising equity is a species of law that through which injunctions or other form-fitting instructive remedies are offered. Under equity, courts have no authority to issue what are called universal or nationwide injunctions, injunctions that don't just bar the government with respect to the plaintiffs before the court, but bar the government with respect to everybody. The court here relies upon an older case written by Justice Barrett's former boss, Justice Scalia, called Grupo Mexicano de Desarrollo, that says equity, as it exists in statute, was frozen in 1789. The court ignores a number of obvious problems with that position. The most obvious for those of you who have engaged in constitutional litigation is a small and unimportant case called Ex parte Young, which is the case that permits private litigants to sue state actors for injunctions. That's an innovation that comes almost a century after the founding. The court also grants a stay, notwithstanding the fact that the stay would need to be premised on a finding of irreparable harm to the government. The irreparable harm, as was anticipated earlier on the panel, here is the fact that the government cannot enforce a patently unconstitutional law. It's a new kind of irreparable harm. In JGG, the court held that the Venezuelan plaintiffs had used the wrong vehicle. They had filed under the APA when they should have filed habeas petitions, which would have meant filing in the Southern District of Texas, which obviously has a different bench from the District of Columbia. The reasoning appears to be, and as Carolyn said, there's not much reasoning, is that, well, these are people who are suing for their release. The problem is that that's not what they were suing for. They were saying we're entitled to certain procedural protections before we are subject to removal. A couple of years ago, in a case called Thuraissigian, which was an immigration case, the Supreme Court, with Justice Alito writing, said habeas is a means to secure release from unlawful detention. It is not a means to obtain additional administrative review. So apparently habeas means just release when that helps you find against the detainee. And habeas means either release or additional procedure when it helps you find against the detainee. Good to know that's how it works. The net effect of both of these provisions is to facilitate the persistence of clear violations of the law. That, I think, is apparent in the birthright citizenship case, where the government did not challenge the application of the district court orders to the named plaintiffs, but said whatever happens to those named plaintiffs, we're free to enforce this unconstitutional order against other people. It undermines the legitimacy and credibility of the district courts at a time when the district courts are under both a public campaign of what I would non-technically call slander, including in an opinion piece by Adrian Vermeulen today in the New York Times, and are evidence, I think, that the court simply does not see itself as part of a project of enforcing constitutional rules against a co-partisan president. And I would end just by contrasting the deceleration and the deregulation with respect to constitutional rules that we see in the last 2 years through the presidential immunity case and then through the cases that I've been describing, And contrast it with, for example, the non-delegation doctrine cases and cases like Loper-Bright, where when you have initiatives that are much more likely to be undertaken by a non-copartisan president, initiatives that are regulatory, the court goes out of its way to find standing where it wouldn't otherwise be available. The court goes out of its way to give relief in forms that would otherwise not be available. And so to my mind, it's very hard to read these cases or understand these cases just in isolation, but rather it's I think much more sensible to understand them as part of a pattern where the court is acting as part of a partisan formation.
Aziz, thank you. I don't know about all of you, but listening to Steve, Carolyn, and Aziz makes me want to go back to law school and take a class with them. And listening to Mike and Kevin makes me, as a litigator, wish I was working on a case with them. So we have about 12 minutes left for questions. And I think, do we have a microphone that's going to go around? And this is primarily, well, this is for the benefit of the people in the room and also the people online. Just please use the microphone to ask a question. The first hand I see back there.
Thank you so much to everyone. I'm Katie Watson from Northwestern. I have a question about Skrmetti and Mahmoud and next steps in linking these cases from the parental rights angle. I completely understand why the Skrmetti litigants stuck to the equal protection and the gender angle, but now that that's a no-go, could you talk about the tension between bringing a comparable case in the same state or a different state with a parental rights constitutional law argument and the fear that a positive ruling in that sense will embolden statutes that, allow parents to force their kids to do conversion therapy? Or what are the pros and cons of that strategy? Or is this one of those sleeping dogs lie that we're not going to see in a next round of litigation about these repressive trans minor statutes?
Yeah, thank you. And other people may have different thoughts on this. I actually don't think that is going to have traction. A parent's rights, as I understand the question, a parent's right to direct the medical care of their child for transitional purposes, right? And I want to be clear, for transitional purposes, of course, parents have a fundamental right to direct the medical care of their children. It's the for transitional purposes that I worry about. And the two cases, I think, stand in sharp contrast for reasons that you're suggesting. There is a parental right to exempt your child from what you deem to be offensive material at school, but not a parental right to direct their healthcare in this really important way. What to make of that, I'm not sure, but it's not clear what sort of litigation is going to result from this, but I don't predict that we're going to see a right of parents to direct transitional care.
Is this working? Yes. I want to follow up on what Aziz said and relates to the shadow DACA. It relates to, I don't know if people read Adrian Vermeule's op-ed piece in the New York Times today. So the question is there an coherent ideological defense of what the Supreme Court is doing that counters the argument that they're acting in nakedly partisan or political purposes?
Is there a good faith based?
Well, if they would tell us why they're doing what they're doing, we might be able to answer the question. I mean, I don't mean that to be funny. I mean, it is kind of funny, but how can we answer that question? They're not saying why they're doing it. They're just doing it. And they're doing it with, the 9 cases I count as having reasoning. Again, that's a very, very generous way, just, definition of having reasoning. And then there are cases where some of the most recent stays that they've issued, which have contained zero reasoning at all. We're talking about pages and pages of district court fact finding and pages of conclusions of law. pages and pages about why there's irreparable harm to the plaintiffs, why the equities should be balanced in a particular way. So, I think I don't know how to answer that question. Maybe I'm skeptical. I think they don't all agree with each other, actually, is I think part of their problem. And that's a good reason in my mind for them not to be issuing these stays. They should let the cases develop and then decide them when they have a full record and a fully developed legal arguments. But they literally are leaving themselves wide open to this accusation by not providing the most basic thing that courts are supposed to do, which is reasons.
Well, Steve Vladek, who is a law professor at Georgetown, has a good piece in his Substack this morning. I think I write quickly, and Steve writes like 10 times as quickly as I do. Like Steve's piece very nicely identifies many of, I think, the egregiously fallacious statements that are in the Vermeulen op-ed. To my mind, it was malpractice on the part of the New York Times editors to accept that piece. It's one thing to have a diversity of opinions. It's another thing to have diversity of willingness to lie about the world. The question of whether the Supreme Court has a coherent ideology, I think, is, if you push on that, you get to what I find a quite troubling answer, which is this: if one reflects upon the cases that the Supreme Court's ruled on with respect to, say, campaign finance or voting rights, and in particular the strength and application of the Voting Rights Act, what you perceive is on the surface a very, very thin understanding of democracy, an unwillingness to enforce norms under which democracy is inclusive and meaningful, as opposed to merely a kind of performance. And on the other hand, the court, except when it comes to protecting people through environmental law or consumer protection law, right? The court is committed to what I think you could characterize as a Praetorian vision of executive authority. So you put those two things together, right? Thin democracy and a powerful executive, and you do have a coherent ideology.
I'm Jimmy Hurdig. I'm a 2L at the University of Illinois College of Law. I'm curious, Professor Shapiro, you talked about the non-delegation doctrine. Do you see any challenges to the president's tariff policy using the non-delegation, or any other administrative challenges?
Yes. And there is, in fact, litigation going on right now against the tariffs. There was oral argument, I believe, yesterday in the Federal Circuit. And I haven't followed it closely enough to be able to say whether it includes a non-delegation argument. Aziz is nodding, so.
Yes, but mostly a major question.
But mostly major questions, right? There's a statute that purportedly gives the president the authority to impose tariffs under certain circumstances. There's, I think, also just, what the president is doing is not, I think, fairly, in my view, just as a matter of statutory interpretation, fairly encompassed within that authority. But then there are these additional major questions doctrine and non-delegation questions. As far the little bit I read about the argument yesterday, maybe Aziz knows more, is that the court was not particularly friendly to the government's position, but I didn't follow it closely. So, yeah.
Thank you for your presentation. How would your views be impacted if you started from the premise that the Trump administration will come to an end in 3.5 years and that courts come and go? There was the Warren Court at one point, which was deemed to be very activist and with a particular point of view. And supposing you were looking at this from a little longer perspective than just the next 6 months or 2.5 years, how would that impact your evaluation of some of these decisions?
throw out a start. I mean, we talked to some extent about these issues in my constitutional law class. I think one thing that's different today is, there's a section in the common law book that I use and probably many others about what are the restraints on the Supreme Court. Impeachment of justices is one. Well, clearly that's not going to happen anytime soon. Another is the appointment and confirmation process. But there's a huge political science literature now about the breakdown of that, about how skewed the Senate is structurally toward small states and red states, meaning that conservative voices and voices from smaller states are far overrepresented in the process that's supposed to assure some accountability and some check on the president's ability to appoint justices. Then you throw in gerrymandering into the mix. I think that one of my sort of favorite approach, my approach to constitutional law is that it's a dialogue, something Barry Friedman called it the dialogic approach to constitutional law, that over the long term, con law is a dialogue between the court and the people in the country. And over history, over time, the court has rarely gotten too far out ahead or behind of public opinion, public attitudes. And when it did, it was quickly slapped back. FDR's attempt to pack the court and so forth. The mechanisms that are available for imposing control or accountability on the court seem to have broken down and don't seem to be what they were 30, 40, 50, 60 years ago, in part because of political forces, both polarization and the structural makeup, the Electoral College and the Senate, which prevents politics from perhaps being as representative as they should be of what actual attitudes and preferences are in the country. That's one thought, one start answer. Anyone else?
I'll just to put a slightly finer point on what Steve said. The court as it exists today is extremely minoritarian, right? I mean, when you think about which presidents were elected with a popular vote majority and who got to appoint and how many they got to appoint, and then Steve's point about the Senate being not representative. So the three most recent the three Trump appointees were all appointed by a president who received did not receive a majority of the popular vote, did not even receive a plurality of the popular vote, and who were confirmed by the votes of the senators who collectively represent millions of Americans, fewer than the Senate that voted than the ones that voted the other way. Combine that with what happened when Justice Scalia died, with Mitch McConnell refusing to bring Merrick Garland's nomination to the floor. Combine that with rushing through Justice Barrett's nomination after Justice Ginsburg's death. Combine that with just the happenstance of who dies when, which is what we get with lifetime tenure, and then strategic retirements. We have this extremely minoritarian court: 6 Republican appointees, 3 Democratic appointees, and they're obviously the 6 are very conservative. I think that one way of thinking about that is that the small d Democratic inputs into the court that help make up this dialogic component, which I agree is historically what at least one way of understanding much of the history, at a very high level of generality, that's broken down. Those small d Democratic inputs have broken down, and so the reforms are necessary to bring those back in. I personally, at this point, think adding seats to the court is an imperative. Should we find ourselves in a situation where that's politically plausible, which is, I think, a big if.
Jerry, you've been waiting. We're short on time, but if it's a quick question.
Right. I'm Jerry Brown. Is it possible that the court is acting in part out of a fear of avoiding a constitutional crisis if they explicitly ruled against Trump and Trump just unambiguously and explicitly refuses to follow the order? Where does that leave the court in terms of its damage to the institution?
Kevin, Steve, Mike,
Well, I can weigh in really quickly. My own view is, yes, that is a possibility. I know some others have floated that as well, but I think in doing that, the court's making a grave error with an administration that is acting lawlessly and inviting and allowing this administration to continue to act lawlessly for reasons that Carolyn and Aziz talked about is putting us in a constitutional crisis.
Yeah, put slightly differently, I think if that's the court's underlying assumption, then the assumption they're guarding against, the damage has already been done in a sense, right? I mean, if an administration can sort of cow the executive branch, the executive branch can cow the judicial branch into that kind of submission through sheer force of will, such that they're not carrying out their constitutional duties, we've already crossed the Rubicon.
On that happy note, thank you. I mean, this is. Thank you to our speakers. This is a high point of the summer for all of us. We look forward to this. Again, thank you to Mayer Brown. Thank you to ACS and the ACLU, and we will see you next year.
See you.